All right, let's get to the search cases, because I know that's what we would normally be talking about, and we normally go through like 4 or 5 actual Supreme Court cases to talk about these standards. But before we do, we're not actually going to go through the cases specifically, but question for you is the Fourth Amendment talks about no unreasonable searches or seizure. What is considered reasonable? And then they have the term probable cause. Okay, what is reasonable and what is probable cause? Could you talk about that maybe?
Yeah, absolutely. So the Fourth Amendment generally does not allow a search or a seizure to occur unless certain conditions are followed. So number one, you could give consent. So anyone can allow their items or their possessions or their home to be searched. So that's an exception. Number two would be if you have a warrant. The police have a warrant, then they're allowed to search. And number three would be some kind of extreme circumstance, like if the police heard some individual in jeopardy, or who was facing bodily harm, or if the police heard someone about to destroy evidence. Then that's what we call extenuating circumstances that police can then jump in and just stop the person from harming someone else or stop the person from destroying evidence. So probable cause is a standard in the criminal context where police have to be pretty darn certain that a crime has been committed, upwards of in the 80 to 90% range.
Now, how do you know if a police officer is 90% sure?
That's what
their discretion again.
Correct. It's their discretion, and it's difficult because there's no, human beings are not robots, and so we can't look at a scale, and we're just sort of depending upon what the officer's testimony is later on as to what he observed, and based on his experience and his training, what led him to be so certain. But that is something that's often challenged in court cases, is saying, based on these circumstances, officer, you should not have been this certain, and there was not probable cause.
Would it be enough? So sometimes people say, well, the officer might say, can I search your car? And you say no, and the officer says, well, only a guilty person would say no. Is that probable cause? Is that reasonable?
So no, that's not probable cause, and that's not reasonable suspicion, because if you decline to allow a police officer to search your car, effectively what you're doing is you're exercising your Fourth Amendment right. And so the police are not allowed to use that against you. It's actually similar to during a criminal trial, defendants have the right to not testify. They have the right to sit silent, exactly. And years ago, sometimes the prosecution in their closing argument would say things like, he didn't even testify. That shows you he's guilty. If an innocent person would have testified, and now the rule is the prosecutions are not allowed to say that, because again, what they're by saying that they're using it against you when you invoke your rights.
Like there might be a reasonable way for you to say, I don't want a police officer going through my car. I'm not guilty, but I don't.
Correct. Absolutely. There could be many, many reasons why an entirely innocent person does not want a police officer searching their vehicle.
Okay, well, how about this, Adam? Can I give partial consent? Meaning, I get pulled over, a cop says, I would like to search your car. I say, yes, officer, you can search everything except the glove box.
Yes, absolutely. Partial consent is allowed. You can tell the officer, limitations on what he's allowed to search and what he's not. And if the officer agrees to that, obviously they could say, forget it, I don't want to search at all. But if they want to search within those limitations, they have the right to. You could say you can search everything but the glove box. The other thing is you can revoke consent once it's given. So you can give an officer permission to search the car, and then halfway through the car search, if you say, you know what, I've changed my mind, I revoke consent, consent's revoked, and they have to stop at that point.
Wow.
Of course, anything they have found up till that point they can use, but at that point, if consent is revoked, they have to stop.
Interesting. Very interesting. Okay, well, what if they are looking for a weapon? Maybe they're in your house. You've given them consent. Or maybe they have a warrant. Let's just say whatever they're doing in the house is legal at the time, but the warrant is saying we're searching for a weapon. But then they find a bag of illegal substance, a bag of, I don't know, cocaine. Do they have to get a separate warrant on that, or can they act on the new evidence that they find?
They can act on the new evidence that they find, and that's actually called the plain sight doctrine.
Okay.
So let's say I have a warrant to search for a handgun, okay, and I'm searching your house, and I open up this drawer to see if the handgun is in there that I have this warrant to find, and when I open up the drawer, I find this bag of cocaine that Mr. Lindquist referenced. I, at that point, as the officer, can act on that because I had the legal right to be in the drawer, so to speak. The warrant for the gun allowed me to legally search the drawer, and in my act of legally searching the drawer, I found this other illegal substance, and so I'm allowed to act on it. And I do not need to go back and get another warrant. In addition to the plain sight doctrine, there's also something called plain touch, where, again, similar circumstance, let's say an officer is searching for a handgun and he's reaching up to the top shelf of a closet and he's patting down the towels and he feels, he's looking for a handgun, but he feels something that feels like powder. So, and by his training and experience, he thinks that's cocaine. Plain touch goes along with plain sight. He had the legal right to be up there looking for the gun. He innocently found the drugs while he was up there, and therefore he can act on that and does not need to go back and get another warrant.
Let's make this a little trickier. Let's say a tuba was stolen. In case you're not a band student and you don't know what a tuba is a very large instrument. Let's say a tuba is stolen. They have good reason to believe that Mr. Lindquist stole the tuba. I would never do that. But let's say they have reason to believe that, and they have the warrant to search my house for a tuba. And then they start going through my drawers, like the cabinet drawer that I would fit, paper files in this big. Would that be a legal search for them to search in there?
So generally, no. Generally, a search must be narrowly tailored to sort of the goal of the search. In this case, it'd be finding the tuba. So if the police were searching for a stolen tuba, they would be limited to searching in locations where the tuba could reasonably be found. So that might include, in a closet, in a garage, under a bed, in a crawl space, but it's not going to include in a desk drawer because tubas are too large. Obviously, it would not fit in that desk drawer. And so if the police officers, when searching for the tuba, are going through your desk drawers, they're basically just going on a fishing expedition at that point, trying to find something. And that's why it's not allowed. So the general rule is, if you're looking for the tuba, you can't go in these spaces that are way too small to ever have a tuba concealed therein.
It's so interesting to me that the Fourth Amendment is literally one sentence long, and yet all these questions come up, and it's, well, what would the founders say, and what do the judges say, and how do we interpret that? And yet all these rulings based on court cases are viewed as law. That's case law. That's the Fourth Amendment protection, even though the Fourth Amendment is no unreasonable search and seizure. What does that mean? And this is what we've been figuring out. Now, here's the famous case that I've told you since day one in the class. Knock at the door. Dun, 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 dun. Police. Okay, open the door. It's my wife and my home. My wife is very nice. Mr. Lindquist, not so much. My wife opens the door, and the police say, hey, can we search the place? No warrant. They're just asking for consent. My wife says, well, gee, absolutely, come on in. Mr. Lindquist says, you can't come in, get out. One yes, one no. Can they come in?
The answer is no. And it's actually a very interesting case. The facts of it are very similar to what Mr. Lindquist just said. And the court, this was addressed by the United States Supreme Court, and in addressing this issue, the court ruled that societal norms would dictate that if someone received one yes and one no at the front door, they'd probably not come in.
So if you were coming over and my wife said yes, come on in, and I said, Adam, get out, you probably
would get out.
Okay.
I probably would not come in over your objection. And so the court said that essentially the police should be held to the same standard as others in regard to these societal norms, where when one party says yes and the other party says no, the person who's coming over probably follows the objector and probably does not come in. So in a case where one person who owns the house says yes, the other person who owns the house says no, the no controls.
What if the police are like, oh, okay, well, here's what we got to do. We got to arrest that guy who said no. And they arrest me, put me in handcuffs, take me off. Then they ask the question again, and my wife says, yes, come on in.
So that's it's a very interesting sort of twist and sort of a hybrid on that situation we just discussed. And there was a United States Supreme Court case called Fernandez v. California that addressed this exact situation. And so the rule is that if the police have a reason to arrest you, they can, in fact, arrest you and remove you from the scene. And then once you're gone, if your wife is there and she allows the search, you're not there to object to the search, then the police can conduct the search, even though you would have objected had you been there. In that case, Fernandez was arrested by the police, while he was gone, his girlfriend consented to a search of his apartment, and they found evidence against him. He said, well, hold on a minute, I would have objected to it, but you arrested me. The only reason why I wasn't there to object to it was because you took me away.
No.
And the police response to that was, or the court's response to that was, well, we had reason to arrest you, and that's why it was okay. So to be clear, the police can't arrest you, the police cannot arrest you just to remove you so you don't object to the search. So they have to have some justifiable reason to arrest you. It cannot be just to stop you from objecting. But if they have a reason to arrest you, and they do that, then whoever's left at the scene can consent to the search, and since you're not there, you won't be able to stop it.
Okay, well, let's take it a little bit further. I know we're getting in the weeds on this Fourth Amendment some more, but I find it so interesting. So let's say spring break's coming up. I'm going to go down to Florida, and let's say I have somebody dog sitting, house sitting for me, and police come over, knock, knock, knock. My house sitter opens up the door, and the police say, hey, can we search the place? And the house sitter, who doesn't even own the place, can they consent to a search?
Yeah, that's a really interesting question. So that deals with an issue called apparent authority. And so the house sitter, it's going to depend on what she conveys to the police at the time they come over. Now, when the police come over and they say, hey, can we search the house? If the house sitter simply says, sure, go ahead, and it appears to the police like she's an owner, it appears to the police like she has the authority to consent, then they are allowed to consent. And then they are allowed to go in and search the home.
But if she says, hey, well, I'm the house sitter, but I don't care, but I'm a house sitter.
Correct. Then the police are not allowed to search. If the house sitter says, well, I don't live here, I don't own the place, but I don't mind if you search, then it's clear to the police that they do not have an owner's consent. But if it looks, but if she leaves that information out and she just says, sure, go ahead and search, and the police say, well, we thought she was the owner, how are we supposed to know? Then they're allowed to rely on her apparent authority, and they're allowed to conduct the search.
So be careful who you have house sit, in other words.
Correct. No one who will consent to a search.
Wow. Okay. Well, geez, we're coming towards the end. I guess, for you guys, because you're high school students thinking about going to college, does the Fourth Amendment protect you in a college dorm room? Do I have any legal protection? I don't own the place. The school owns the place, so it's not quite like being here at the school with your locker, because you do live there, but you don't have any ownership to that place. You're just paying for your dorm room. What are the search protections like there in a college dorm room?
So those who reside in a college dorm room do have Fourth Amendment protections to that space. And it's similar to what you'd have in an apartment or another leased or rented space, which is that if it's your domicile, it's where you primarily reside, you essentially have the same protections as you would in the bedroom of your home. So the police still would need a warrant before searching your dorm room, and it would apply the same rules that we've discussed. The warrant would have to be narrowly tailored. They'd have to stick to only locations where what they're looking for could be found, and all of that would still apply.
Well, how would this same case relate to an apartment where you had roommates had each separate rooms?
It's a good question. So let's take a situation like Mr. Lindquist just said, where you've got 4 roommates. Each roommate has a bedroom. They're living in an apartment, and there's in addition to having their own bedrooms, there's common areas. There's a common kitchen, a common living room, for example. So under that scenario, any one of the roommates can consent to their own bedroom being searched as well as the common areas. So if I'm one of the 4 roommates, I can consent to the police searching my bedroom, I can consent to them searching the kitchen or the living room or whatever other common areas there may be. However, I cannot consent to a search of my roommate's bedroom. So essentially, space that is universally or exclusively yours, your roommate is not allowed to consent to a search of that. However, space that is shared with the roommate is allowed to consent to a search of the shared common space.
Well, that's a lot, Adam. That's a lot we've just covered. A lot of ground. I hope you found it interesting. So much nuance to the Fourth Amendment. So much nuance to the First Amendment, which is why we were able to spend, 2 entire class periods talking about just those 2 amendments. And, we didn't even get into all of it either. I mean, the First Amendment has 5 freedoms: RSPAP, religion, speech, press, assembly, petition. We just focused on speech and student speech and online speech, and now we've talked about search cases. So obviously this stuff is interesting to me and to some of you who've asked, what are my rights? I have rights. What are they? And how do they determine that? Now we've seen that it's the judicial branch's role who's made this a lot clearer. Okay, unreasonable search means this. Free speech means this. Adam, anything you'd like to add before we close out the video?
I would like to simply say again, thank you very much to Mr. Lindquist for having me into his wonderful class. Thank you to the students. You guys were great, very engaged, and you asked great questions. I was really, really impressed, and it was a pleasure meeting everyone.
Excellent. Adam, appreciate it.
Thank you, sir.
Till next time.